Welcome to Conveyancing Matters with Lorraine and Stu. Join us for a chat about all things property.
Hey, my name's Scott Hastings. I'm with Mortgages by Scott, and I am a mortgage broker based in Charlotte, North Carolina, and I help clients all over the Southeast get mortgages. So today, I have two wonderful guests that have, very kindly offered their time to explain a little bit about how real estate transactions, and particularly conveyancing, which is a term that we will learn about today, happens in the UK. Their channel is Conveyancing Matters. So welcome, Stu. Thanks for coming on with me today.
No problem. Thanks for the invite, Scott. Yeah, so my name's Stuart Forsdyke, and I'm one of the managing partners of a law firm called PCS Legal. So over to you, Lorraine.
Hello, and hello, Scott. Thank you for inviting us. So yeah, my name's Lorraine Richardson, and I am a solicitor, so a lawyer, and I now do two things really. I'm now freelance. I do locum property work, so I still work in practice, but I teach. I've taught for a very long time, teach property lawyers how to do it. And as you said, Scott, Conveyancing Matters is a YouTube channel that Stu and I started actually in the depths of lockdown. Just to sort of talk about the process of buying and selling property in England and Wales, and we talk about a whole host of stuff really. I think we've got about 100 videos up now, so we've sort of carried on post lockdown, and that's how you found us, Scott. So thanks for looking us up.
Absolutely. Well, the reason the backstory, the reason I looked you guys up and came across you was, here in the United States, obviously real estate transactions are different from, other countries in the world. And just yesterday, today is actually November 1st, 2023. Yesterday, there was a legal case that had a resolution, I guess, where the National Association of Realtors and Keller Williams was being sued by a consumer group in the state of Missouri. And the lawsuit was settled for $1.78 billion. Of course, that will be, that won't be the end of it. There'll be more lawsuits. But really the crux of that was that the National Association of Realtors, and at the end of the day, all of the different big real estate firms have done price fixing and colluded to artificially keep real estate commissions high. And so whether that's right or wrong, I don't know, but I think it will change what's going on with how real estate is transacted in the US. And I understand that, or I don't understand, that's what I'm here for. What I wanted to sort of ask and find out from you all is, how does the real estate process work in the UK, England, and Wales, as you said, and what is a conveyancer, first of all?
Right. So, do you want me to start, Lorraine?
Yeah, you pick that one up first, too.
Right. Okay. So, conveyancing, by its definition, is the transfer of a property or land from a seller to a buyer. And on our channel, we've interviewed people from different places around the world, and we've seen the distinct differences. But in the UK or England and Wales, it's quite definitive, the role of the estate agent and the lawyer. And the estate agent is solely there to sell the property. A seller will go to an estate agent finds a buyer for that property, the deal is agreed. But at that point, the estate agent doesn't have much more involvement, or, in particular with the legal process. It's a conveyancer that then steps in. A conveyancer then looks after all the legalities behind getting that client from that point, having the sale agreed, up until completion and the money passing hands. So there is a big difference between how it works over here to maybe how it works in America and other places, and I think it's that separation between the agent and the lawyer. What would you say, Lorraine?
Yeah, I mean, certainly that initial distinction, absolutely right, Stu. I mean, your specific question, Scott, what is a conveyancer? I mean, it's become a sort of generic term, really, for the lawyer that handles the conveyancing process, either on behalf of the seller client or the buyer client. And generally, the distinction is that we have two sort of main regulators in England and Wales. The Solicitors Regulation Authority regulates solicitors, and a solicitor like me, I can do a wide range of different legal work. I just happen to have specialised in property. The other regulator is the Council for Licensed Conveyancers, and the other sort of type of regulated conveyancing professional, Scott, would be Stu, who is a licensed conveyancer, which is a recognised, regulated legal status and qualification. But specialising specifically in property and the transfer of sale and sale of land. And lots of unqualified people do the work within law firms, Scott, but they have to basically be sort of overseen by qualified people. But conveyance has become itself a fairly generic term, but it describes the lawyer dealing with the transaction rather than, for example, what we would call estate agent.
Okay, understood. And so if I make sure I get my terms correct, so would an estate agent in your definition be what we would call listing agent? So that would be the realtor in our world that, meets with the seller, decides the price, puts the sign in the yard, and, that would be the estate agent. Okay.
Yeah.
And then
takes the photos, puts it on a,
right.
Puts it on a selling portal, and, arranges for buyers to go round and have a look. And when a buyer comes along that says, yes, I want it, agrees that, as Stu said, the sort of the in principle sale price.
Right.
But at that point, Scott, really important, that's no more than an in principle sort of agreement. And at that point, generally, the seller and the buyer will instruct their conveyancing lawyers. A big discussion over here, which we might get the chance to talk about, is whether or not the lawyer should be involved earlier in the process. But right now, that's broadly how it's done.
I think also, Scott, just to elaborate on the actual process as well, when the estate agent's involved at the onset and they deal with both the buyer and seller, when the deal is agreed, neither party are legally bound. It's at this point when it gets handed over to the lawyers that the due diligence starts. So where we actually look into the property on behalf of the buyer and start the legal process. And we run that up to a period where we do something called exchange of contracts. And that's the point, which can be several months later, that both the buyer and the seller are legally bound, not at the onset.
Okay, that sounds like a big distinction, here in America. As soon as both parties sign the contract, that the listing agent or estate agent, as y'all say, sign it, then it's a legally bound contract. Sounds to me like what you're saying. It's not legally bound until they agree and it goes to the solicitor/attorney, or not solicitor, conveyancer/attorney, and they sign off on it. Then it's legally binding, and that's where the money's exchanged. It sounds a little bit like a title, sort of like in North Carolina, a real estate transaction has to be closed by an attorney. In most states, like California, for example, it can be done by a title agency. So it sounds like there might be some similarities there. I'm not sure.
I think there's a number of parts that cross over, aren't there? Like number of bits that do cross, but in essence, a conveyancer, whether it be a solicitor, a licensed conveyancer, or even unqualified working under somebody that is qualified, they will look after the whole of that process. There aren't any sort of crossovers or a matrix of different parties involved. They oversee the whole lot.
And technically, somebody, a lay person, Scott, actually could do their own conveyancing if they wanted to. They could be unrepresented, albeit these days, given the difficulties with money laundering and source of funds, source of wealth, there are very few property lawyers, very few conveyancers that would accept that position. But actually, the drawing up of the transfer document is something that actually only a qualified individual can do. So as Stu said, when all of the engine room of the transaction is from instruction of the solicitor to exchange. Stu and I would exchange on the phone in a couple of minute phone call, and at that point our seller and buyer are legally bound. At that point, the completion date, the moving date, is contractually agreed, and there's typically perhaps a couple of weeks between exchange and completion, so the parties kind of know when they're moving. But the contract creates the legal obligation to buy and sell. But on the completion date, Scott, when the balance of the purchase money is handed over, 10% is paid on exchange, The remaining 90% is paid on the completion date. That's the moving date. And the document that actually transfers the legal title from the seller to the buyer is called a transfer. And actually, rather boringly, but the document has to be prepared by somebody who is sort of legally qualified to do it. And then the buyer's conveyancer, once the purchase is completed, will then have to apply essentially to register the transfer of the title with the land registry, which is a government agency that records details of title.
Okay.
And also, Scott, as well, on that process, when we're looking into the property, if at any point the client simply decides to change their mind, or we actually find a problem with the property, they can withdraw with no recourse to the seller whatsoever.
Prior to exchange.
Wow. Okay. Yeah. Okay. That's very different. So is the 10% that goes into escrow, is that negotiable, or it's 10%?
Pretty much 10%, Scott. That's the sort of industry average. That's the amount. Anything above that would probably be seen as a penalty. The only instance where somebody might offer less than 10% was, for example, if they were getting a mortgage for 95% of the purchase price, which is much less common now than it was. I think it's fair to say, Stu, isn't it? But de facto, if they've only got 5% to put down because they're getting a 95% mortgage, then the seller's got a bit of a no choice there. They accept 5% or nothing. But that 10% is key, Scott, because particularly if the buyer withdraws without good reason, there are a couple but not many, after exchange, or well before, after completion should have happened, ultimately, and there's a few bits of process, but the buyer would lose their 10% deposit, Scott, if they withdrew, if they didn't complete, essentially.
Okay. Interesting.
So that's the thing that gives the contract its teeth, really. It's that prospect of the buyer losing their 10% deposit that's the key, really.
Yeah. Okay. Wow. So in America, first-time home buyer can only put 3% down. Anyway, we could get on a sidetrack about mortgages. Not final question. So what is the role? You have a estate agent that is the listing agent. Who plays the role of a buyer's agent? So who represents the buyer in the negotiation and all that stuff to find a property there?
There are a number of what we now call deal sources that have cropped up in the market, but as a generalization, the answer is nobody. Nobody in particular represents the buyer. The estate agent acts on behalf of the seller in terms of listing their property, finding the buyer, but the buyer doesn't at that point have representation. Obviously, when they start the legal process, obviously they have their own lawyer, and during that process, us as lawyers, we would advise the client to do things such as have a survey done to make sure that the price stands up, that kind of thing. But in essence, before we're instructed, there's nobody that acts on their behalf.
That is interesting. That's very interesting. So basically, you are looking out for the best interest of really the buyer, because you're making sure the contract up front is put together airtight, everybody's covered, it's legal. I guess you would recommend that they get a home inspection, they would get a survey, all that stuff.
Yeah.
Okay. Interesting.
Yeah.
And
interestingly, Scott, to jump in there, the issue of looking after the buyer's interests, around those negotiations. The reality is that, Stu and I aren't qualified to do that, in the sense that there's quite clear demarcations around what the lawyer can do, and we are not valuers, we are not surveyors. So it would be very, as a general rule, we do not get involved in the sort of negotiations on the price on behalf of the buyer. Now, as Stu said, if, for example, a buyer takes our advice and gets a survey done, and frankly, Scott, most of them don't, which is ridiculous, but that's another story. And the property, 20 grand's worth of work is revealed, then we might kind of go back to the seller's conveyancer and say, look, the property's been downvalued because of our client's survey. Our client only wants to, pay less money.
Yeah.
Or if it transpires that the client can't get the mortgage, and you'd be very familiar with that they hoped they were going to get, then that is the point at which we might get kind of involved in those discussions. But any sort of assessment of value or anything else, that's absolutely not our bag, and that's not liability we can take on.
Okay. How do buyers find properties in there? What Do they just find them online, or how does that work?
Yeah, so there's a number of different what we call selling platforms over here. And as a generic, a buyer that's looking for a property, they would go onto those platforms where most estate agents list what they have on their books. Some will go straight to an estate agent, perhaps, but I would say as a generalisation, most go to 2 or 3 selling platforms, and that's where they'll find the property they're looking to purchase.
Okay.
So like with you, Scott, I mean, mostly, people will often move because of, life issues, whether it's wanting to upsize, downsize if you're older, whether you want to change where you live because of your job or your kids' school. All of those drivers really for why people would move would be, I guess, the same as with you. And as Stu said, and it's actually, it can be quite a pastime over here. People can spend a lot of time fannying about on the internet looking for somewhere to buy. It's quite a thing. So obviously you'd put your search parameters in, whether you're interested in location or price or whatever. And as Stu said, that's how people would discover what they wanted to purchase. And then they contact the agent, the estate agent, maybe to arrange a viewing.
There you go. Yeah. So here the buyer's agent, takes the people to see the house and nobody's there and all that stuff. Okay. Interesting. Well, then that pretty much makes sense.
This case, Scott, you mentioned, I mean, the price fixing, I mean, what's interesting from our perspective over here and is that actually, certainly from the conveyancer's point of view, the estate agent over here will agree a selling fee, a commission with their seller client, often before we're involved, which maybe, Stu, what would you say the average sort of percentage is now for an average property in England and Wales? I'm not talking about, multi-million pound in the middle of London,
something like that, maybe 2% of the purchase price would be about average, I would say.
Yeah, so but that will be considerably more, Scott, than most conveyancing firms will be charging. So what's really interesting from our perspective over here, sort of looking in at your world, really, is the fact that if anything, I hate to say it, but there's often been a bit of a race to the bottom on legal fees for doing conveyancing work in England and Wales, and it's always quite galling to do the the bank transfer for the selling agent on completion on a sale when you see that their figure is probably going to have an additional naught rather than yours.
Yeah, I mean, what's interesting that I see about this case, and this is what really prompted me to reach out, is basically the buyer's agent who represents the buyer gets 3% of the sales price, and the listing agent gets another 3%. So to sell your house here, it's always cost 6% of the sales price. So what
was the basis of the case, Scott? I mean, I'm interested in that, in the broad sense. I mean,
right. The basis of the case was that, and I'm not a legal scholar, but my understanding is that it's basically about price fixing. In other words, the case was that the National Association of Realtors had practices in place. So they have something called the MLS, Multiple Listing Service, and there's different MLSs all over the country, maybe 1,000, but they all are covered by the same rules. And so when they looked at like training videos from Keller Williams and all these things, they were always about how to keep the commission price elevated, right? And that the listing agent, when they put together the sales contract with the seller, they decided that they would make 3% and that the buyer's agent would make 3%. And then that set, and as soon as they signed the contract and agree to even list the house. And what I think you will see is that it's been seen as kind of like a monopoly, that agents wouldn't necessarily show houses that were not offering full commission.
Oh, really?
Right. Or, yeah. So that's basically it. So, before, we could go on and on about this, but, it's not the same as it was 30 years ago, where a real estate agent had a book and they were the only ones who knew what was on the market, right? So like you're saying, everything's on the internet. But the price of selling a house has basically stayed the same. And that's where it took many years for this case to even happen. But this is what happened. Yeah. So the question is, how will this affect? We don't know yet. What I was reading was they really pointed out something called the cooperative compensation rule. And that was what allowed listing agents and home sellers to predetermine the buyer's agent's commission rate. That's what they really, I think, hammered on. And so I think the fear here by real estate agents and maybe buyers is that, well, who's going to pay the buyer's agent now? Because buyers already don't have enough money for a down payment. They certainly don't have enough money to pay 3% more to a buyer's agent. And so it's possible that something like your system and the conveyancer that seems to offer some of the same protections and probably more for a much lesser cost might come into play, right? And that's my thought process.
Yeah, I mean, it's really interesting, and certainly, you know, what we gleaned from our sort of, as Stu mentioned, our discussions with other sort of people from other jurisdictions, is that one of the things, if one of us is acting for a buyer, that can take a significant chunk of the sort of time between instructions and exchange, Scott, is investigating the seller's title, is checking that the seller's title to the land that they're selling is okay. And of course, that's, you mentioned off air that our system can seem pretty archaic, and that's because sometimes we can be looking at, you know, obligations running with the land that can perhaps potentially go back many hundreds of years. Now, what we've certainly seen over here in relation to those sorts of issues, there's been a real explosion in the last few years, Stu, hasn't there, in relation to the use of indemnity insurance. And it's certainly the case that our understanding is that, you know, your titles over there are generally a damn sight less complex than they are over here.
Yeah, I'm sure.
So it kind of slightly, I hate to say it, I don't want to put anybody off and I don't want to offend any of your viewers, but you kind of do wonder in that case what your buyer's agent is doing for their 3%, Scott, because they're certainly not looking at complex titles, are they, Stu?
Definitely.
Well, I definitely don't want to irritate or make them mad either, but
no, but it's an interesting point.
Really what they're being paid for, and they do a lot of work. The most time that they spend is putting people in cars and driving them around to look at a million different properties, and they change their minds and negotiating the contract, and it falls apart, and, you know, holding the client's hand all the way to the end. And, you know, so that's really what it is. And I guess that, you know, I wrote a question down. When, for the buyer, let's say the buyer is in contract and there's a problem. You know, they do the property inspection. There's, you know, water in the basement. They're going to have to do all this work. You know, who's going to pay for it? And the buyer and seller are fighting. Who works that out? Is that the estate agent who's listing the property? It's their responsibility to deal with it all the way through with buyer and seller, it sounds like.
Well, it would depend, Scott, and Stu will have something to say here, but over here it would depend, you know, at what point that problem came to light. It's far more likely over here, as I say, the estate agent will have dealt with the sort of in principle sale price at the outset. Solicitors or conveyancers will have been instructed. That's when Stu would be getting his buyer client to get a survey done. So Stu, you know, a problem like that would, you know, almost invariably be coming up pre-exchange, wouldn't it?
Yeah, of course. Anything that comes up like that, a client would generally let you as the lawyer know, and then you'd raise that with the other lawyer, and you'd come to some kind of agreement as to how that was going to be dealt with, whether it was something that meant that the price would be reduced and a buyer would attend to it after exchange and completion, or a seller would attend to it pre-exchange and completion. But that would be to negotiate. And, you know, at the end of the day, it's the vendor that holds the key. It's their property. They would be the ones that say yay or nay, and it'd be for a buyer to decide whether they want to go ahead on that basis.
Yeah, that's interesting. So it's not the agent at all. It's you all.
Yeah, sometimes the agents would be party to general negotiation, and also as well, we do have, I suppose, strict separation in terms of who acts for whom. We have one lawyer act for a buyer, one lawyer act for a seller. So there are points where you, as opposing lawyers, you can't get something agreed, and the agents will do some kind of mediation. But once that mediation is complete, the issue, so to speak, is always covered off by the lawyer.
Right.
I mean, the thing is, Scott, if a property doesn't survey up, well, that's kind of the point of having it done, and the buyer might walk away completely. I mean, the issue can arise much more rare. Kind of picking up on your point, obviously, if something happens to the property between exchange of contracts and completion, which is that relatively short period of time when all of that due diligence that Stu mentioned has already been done. But if there is a problem between exchange and completion, what's really interesting about our particular form of contract that we use, and it's just for contractual certainty really, is that the buyer is still bound to proceed. Both parties will have been obliged to insure the building. If it's a physical structure on land, but the buyer is actually still bound to proceed unless it can be shown, for example, that the seller has perhaps in some way misrepresented the position. But the sort of basic contractual position is if the place burns down between exchange and completion, the buyer's still got to go ahead and buy it.
Oh, well, that is interesting. That's very different. But okay. So you got to be real careful.
The time between exchange and completion, Scott, is usually very short. The likelihood of that happening is incredibly rare. So
what is short? What is the average time between?
A couple of weeks.
Yeah, week to 2 weeks normally is about right.
Yeah. So here it's probably 4 to 6 weeks, and because really once it goes under contract, then the mortgage process starts and all that stuff. So that's interesting.
Yeah, see, the big difference here is everything has to be absolutely perfect before you exchange and commit to the contract. So things such as having your finance and a mortgage offer in place have to already be there.
Interesting. Very interesting. Okay. I like it. Well, I guess if you all were going to buy a house in America, knowing what you know now and all the people you've interviewed, what would your process be?
Would I choose yours rather than ours? Well, in many ways, I'd choose yours, Scott, because I think there's much less likely to be a problem with the title to the property, quite frankly. And I think it's fair to say it seems, albeit I know it's different from state to state, I think it seems to be perhaps maybe a slightly quicker process. But you know what, Scott, I don't know, where would I choose? I like Santa Barbara, like New Orleans. What about you, Stu?
Conveyancing, what, places in America, or we're just talking about conveyancing processes now?
Probably both.
For me, I would obviously choose the English process because that's what I practice. And for me, I think when we talk to people about different processes in different jurisdictions, one of the key things that comes across is that there are so many cultural differences that I don't think you compare, or you can directly compare one with the other. So, for example, we've already mentioned maybe the title to a property and the fact that here the title to a property could be a lot more complex. So the actual process itself, I don't think you could individually evaluate against another process because there are too many sort of moving parts to compare like with like. But I'm always going to defend our process. That's what sort of I do, and that's what I qualified to do. So it's got to be the UK version. That's got to be the right answer, Lorraine, surely.
Yeah, sure. I mean, Scott, what's kind of interesting for us, as I say, because we have sort of chatted to people from other jurisdictions, and I think I said off air, conveyancers over here, Scott, were under such extraordinary pressure during the COVID period in particular. And then for whatever reason, we have a property tax over here paid by a buyer called stamp duty land tax. And our government sort of to inject, interest into the market that wasn't actually needed. They post-COVID created a stamp duty land tax holiday, and the market went mad, and conveyancing lawyers were absolutely up against it. But I think what's interesting is that Stu and I kind of concluded that, and everybody after that period, Scott, said, oh gosh, conveyancing's broken, the process is broken. But what we sort of concluded is the process isn't broken. There's just lots of other stuff going on around it. And one of the big issues for us, which is, I think, a completely different conversation, but is all, for example, of the additional sort of regulatory requirements and money laundering and checking clients' source of funds and source of wealth. So the process itself isn't particularly bad. It's just that over the years, the number of responsibilities imposed on conveyancing lawyers who are regulated and insured, that's the bit that's added the time, the pressure, and has broken a lot. But the actual fundamental process itself that we've described to you is probably pretty sound.
Yeah, it sounds like it. I mean, it sounds like you all have a lot of additional responsibilities that are really, so you talk about money laundering and stuff, that's part of the mortgage process here. You know, attorneys have nothing to do with that. And so you all have a lot of pressure. One thing I didn't ask, which I think is obvious, what is the typical fee that you all charge for your work?
You?
I would have said there's obviously numerous disbursements, but I would have said a round figure of about £1,000 might be there or thereabouts, correct? I would say as an average.
Plus VAT, we have VAT, a tax of 20%. But yeah, I mean, but as I say, there really has, Scott, over here been with some organisations, some firms, you know, there has been a bit of a race to the bottom on fees, and that has kind of skewed the market a fair old bit, it's fair to say. But I mean, Stu, I mean, just to give some context to Scott, what would you, if your fees were £1,000 plus VAT for PCS legal on an average transaction, what would be the corresponding commission payment to the estate agent on a sale?
Oh, as a comparable, I would have said you're talking 3 to 4 times the amount.
Yeah,
that's considerably more.
I mean, that's about $1,500, I think, something like that, probably. That's about what an attorney here would charge, but they also have to pay for title insurance and all that. So it's pretty comparable. But yeah, I think y'all are giving people a fantastic deal, honestly.
Yeah.
I mean, yeah, I can't imagine a race to the bottom, because that's you're serving a super important role. And I don't think that's where you want to cut costs.
No, I think, and to be fair, lots of people in the business would say that, but I think actually property lawyers over the years, Scott, have kind of allowed themselves to be pushed into that corner. They haven't shouted, and Stu and I talk about this a lot on Conveyancing Matters. We haven't really actually stood up and said, look, this is what we do. And actually, you know, UK PLC really does stand on its house buying and selling process, and you know, and it's real estate, to be honest, that, you know, we're a home owning nation, and you know, the economy is very, very dependent on house buying and selling, and without decent conveyancers doing that job, it couldn't happen, along with all the regulatory stuff that we've mentioned. But I think conveyancers have generally, and I think this is fair to say, Stu, we're pretty poor at saying, you know, what we're good at.
Yeah, I think so. And I think as a generalization, the worth and the importance of what we do is very underestimated. You know, you're spending a lot of money, hundreds of thousands of pounds on the biggest asset you're ever going to buy in your life. And yeah, maybe you know, the kudos that we get for what we do, unfortunately, isn't comparable.
Well, you must have a few horror stories about clients that didn't use good conveyancers. I mean, they must have. Yeah, that's got to be.
Well, it's really funny you should say that, Scott. It sounds like we've primed you, but we haven't. We 3 or 4 times a year we do Conveyancing Matters live, when we kind of, you know, we go to a dive bar and do kind of, you know, chats about conveyancing with a beer in our hand. And we've got one next week, funnily enough, and it's really weird because we are doing, aren't we, Stu, conveyancing disasters, you know, when things go wrong. So that's exactly what we're going to be talking about next week. But I promise you we didn't prime you. Okay,
I'll have to tune in, because now I am.
Yeah, well, you'd have to come to Shoreditch, I'm afraid, Scott. We won't record it. Me after 3 beers, no. But I think also what's interesting over here, and I don't know whether you get that over there, Scott, but there is nothing more important to the great British property buying public than the fittings and contents in the house. As Stu said, they're making the biggest investment of their lives. But the importance that the client will attach very often to, you know, the buyer client will attach to You know, do I get the sofa and do I get the curtains is quite extraordinary. And Stu and I could be telling them all sorts of really important stuff about the title to their property, and they're yeah, but you know, do I get the wardrobe in the bedroom?
Well, yeah, it's a little different here, but you know, people want immediate gratification in this world. Here, anything, you can't have that on a contract if you're going to get a mortgage. So unless it's attached to the wall, it's not transferable. So because then they say that's an inducement to purchase. So like if you want the couch, it's got to come out of the contract and you do it on the side. But anyway, yeah.
Yeah, I mean, we have a similar thing over here in that if something's become sufficiently attached to the land, Scott, it's a fixture, and you know, and you essentially the seller can't take it unless they agree to, kind of thing. But we do have a 6-page fittings and contents form that's attached. So if anything extra is going to be paid, that will be shown in our contract, but as an extra. But yeah, I mean, I had a client once, I mean, Stu and I could bore you with these for hours and we won't, but I had a client once, quite honestly, and I swear he threatened to pull out of a purchase, Scott, because the seller said she was taking a light switch on the wall. You know, dimmer switches, you get dimmer switches where, you know, turn the light goes up, light goes down. I promise you, he threatened to pull out for the sake of a dimmer switch. I kid you not. So, you know.
People are crazy.
They are.
Universally.
I think so.
Oh, well, it's been a pleasure. I really appreciate it. Is there anything else y'all wanted to cover today?
No, I don't think so, Scott. I mean, the one thing I would really like, though, is you kindly invited us onto your show. We're both going to,
yes.
But equally, we'd really love it if you'd do us the honor of coming onto ours, and then we can ask you about particularly maybe the mortgage process and stuff in the States, and maybe you know, and maybe early next year the sort of fallout from the case that you mentioned. I think it would be great for us to question you.
Yeah, that would be fantastic. Absolutely any time.
Excellent.
That would be great.
It's great.
Well, good deal. Well, I've enjoyed it. It's been really nice meeting you all. I wish I was in France.
So do I. Frankly, we interviewed one guy, Scott, who was in Venice, and Stu and I were very, very jealous, and we thought next time we interview him, we're just going to have to go and do that one in person. Clearly,
absolutely, it's only fair.
Well, it's really nice to see you. Thanks for inviting us onto the show.
Thank you. Y'all have a great rest of the week.
Take care.
You too. Take care, guys.
Thanks. All right. Bye-bye.
Bye.